of the appeal and the application in tax Hoey and the commission of Her Majesty Revenue and Customs.
Good morning, my lady, my lord. The court should have received 3 further authorities, which I hope to address very briefly. They just arise out of points which came up yesterday.
Yes, thank you. We have, and we thought they were helpful.
The first one is the case of Chilcot, which is a Court of Appeal decision considering the predecessor to what became Section 222 ITPA. I think I was perhaps being less clear than I ought to have been in terms of explaining how Section 222 works. I think the Chilcot case makes it perfectly clear.
Yes,
it's a grossing up provision. It creates an amount of deemed income.
It acts as an incentive to the individual to repay the employer.
Yes.
The amount that has had to be paid over as PAYE.
Yes. Well, I think an incentive to repay within a fixed time period, because I think what comes up certainly in the earlier cases, they say, well, there's a restitutionary remedy anyway.
Yes.
And I think the complaint was effectively, if you pay after, it was 30 days then, it's now 90 days. If you pay after 30 days, you get hit with, I think, 56% for £100. If you pay before the 30 days, you only get hit with 40% because there's a deemed extra 40 of income. So,
I has some sympathy with the hard lap case in Chilcot.
yes. Well, of course, if the revenue are right in this case, the issue doesn't arise going forward because they could ask the revenue to exercise the discretion. The second document, and I fully take on board the court's comments on our argument about constitutional principle, but it's the Bill of Rights. I did make reference to it yesterday in terms of levying money being a practical concept, so I just provide that to follow up on that.
Yep.
The third document is Section 145 of the Finance Act 2003. We did look at the explanatory notes to this, but I'm following up on a comment of my Lord Justice Henderson about where the various amendments came in. This seems to be in the section which did them all, including the amendment to Section 710.
No, thank you very much. It's often helpful actually to have the enacting document as well, when one has documents which otherwise one has to pick out from
Yes.
half a dozen different places.
Absolutely, my Lord. And you can see it in there. And in terms of the explanatory notes, what we do say the reason for putting that in was to make it clear that notional payments and deductions are being treated in the same way. And that's at page 325 of the legislation bundle. So,
Mr. Mullen, you'll bear in mind that we'll have a break for the transcriber for 5 minutes at about 11:45.
Certainly, my lady. To recap very briefly where we got to yesterday, our primary position goes to the construction of Section 6847A and Regulations 185 and 188. And what we say is that a power exercised retrospectively under Section 6847A has no impact on the rights under Section 185 because 7A is all about relieving the payer of a liability. And in terms of 185, it talks about an amount of tax which a person was liable to deduct. A retrospective pardon of an obligation doesn't alter that, and actually you've got provisions on direction tax which show expressly how it's meant to be dealt with. Context, we say, is very important, and relevant context here is limited rights of appeal. We made the points on the principle of legality. Of course, Section 222 is relevant there as well. We say it doesn't operate to retrospectively remove rights, and you need an express provision to do that. We say that they exist. And finally, this is a case where the general excludes specific. There is specific legislation with clear boundaries, and we say that's what ought to have been used. We then looked at the policy, what it is, the major point to take away being that if the employer was aware of the arrangements, then HMRC say they will not exercise their discretion. There's an issue on the candour on part of the revenue, but now I want to address on the failure to properly address that central issue, the knowledge of the end user. And what we say is that having identified that it was a relevant consideration, HMRC were under a duty to investigate it and investigate it properly. and that it was irrational to assume that there was no such knowledge and to decline to take any meaningful steps which might reveal what the knowledge of the end user was. It was also, in that respect, unreasonable to put the onus on the employee, as the employee doesn't actually know what the end user knows, and he's not going to be the end user's only source of knowledge. Having identified that what the end user did by way of due diligence was relevant, it was then irrational not to ask the employer what the user had done. Now, I think there was a point made by my Lady Justice Simler about, well, we don't know what further steps they would have taken. And certainly, I think if the point was, we don't know who the end user is, you tell us who they are, and we'll go off and do further investigation, then clearly that would address the issue.
I'm not going to rise every time and then if friend makes a point that's not in his grounds, but so far as I can recall, there is no pleaded ground that it was irrational for the revenue not to ask the end user what they knew. Quite a lot of what my friend has just said is not in the grounds. He does, to be fair to him, make one point about non-compliance with the manual, which he said imposed itself an obligation to inquire, but a rationality argument is not pleaded.
Just to be clear, my lady, I was responding to an argument which my learned friend puts. We say that there was a duty to investigate what the end user knew, and what he says is that, well, actually, that's a question of irrationality as to how far you should go in terms of investigating that. And so that's why it comes in response to the argument which he puts.
So, but what's your positive case on that?
Our positive case is that there's a duty to investigate what the end user knew. And they didn't do that. And the way in which they didn't do that, to the extent that it said that irrationality is a relevant test, was irrational. As I was saying, that if the point of the letter was to say, well, actually, we'll take further steps and we will inquire, then I think we might say, well, actually, that does meet the duty because we have to accept that there's a limited amount HMRC can do to inquire into what an end user knows when they don't know who the end user is. But that doesn't appear to be what was happening. And if it was what was intended to happen, then we'd say that the way in which the letters were worded was even more deficient. But the reason why I say it doesn't appear to be what happened is because of the way the issue arose in the Ado case. Now that's at the core bundle at page 426.
Sorry, which tab?
Tab 20.
You mean the core bundle? You mean the authorities bundle?
No, the core bundle. This was a...
Sorry, 426 is the middle of Lady
sorry,
Justice
it should be
Andrews'
424.
424.
Is where the decision starts. 426 is where I want to take the court.
Oh, right, so we're looking at the judgment of Mrs. Justice Andrews as she then was.
Yes, so this was...
No.
Tab,
So which
tab
tab?
20, core bundle, 424.
So in formal terms, this is an annex to the acknowledgement of service in the JR, is that right?
Yes.
Ah.
You going to deal with the fact this is a permission judgment, which you don't have authority to decide?
No. Sorry? We're not... Sorry. What we're citing this for goes to the way in which HMRC dealt with the investigation. And that's dealt with in paragraphs 11 and 12. And the point being that the most that the taxpayer was able to say, and this is the bottom of paragraph 11, was that the end user had constructive knowledge, notice, or may have known. And despite that, there appears not to have been any further investigation.
In this case, you mentioned that the end user had made the most forthright, detailed inquiry as to who the employer was and what the position was. What they would have been told is the employer, although being overseas, has voluntarily registered for PAYE and is making full PAYE returns in relation to this income. And surely that would be a complete answer. What would the end user possibly have to ask further? What could they have found out?
Well, one of the points is how are you getting paid? Is it by way of loan?
But why should they ask that?
They're told that the employer
told-
has a... Sorry, I'm terribly
Go,
sorry.
no, you go.
They're told that they'd be told that the employer is voluntarily making join the PAYE scheme. Why should they go any further than that?
Well, in terms of what the level at which the policy is set at, that's HMRC's choice, and what they've said is the employer aware of the arrangements? And so sort of having to accept that the policy is what the policy is and not going behind sort of why it was set at that level. The question is, well, have they done that? As to why they should they have to go any further or not, and this comes up a little bit from Farland's evidence. There's a suggestion that, well, nobody knew these things were taxable anyway, so why should they have to pay the tax in relation to them? Well, the answer is that in that situation, the employee, the contractor, is no more culpable than the employer or the end user. So why is it thought fit that the obligation to pay should be fixed on the contractor rather than the end user?
Because the contractor has the money.
Yes, but the way in which the parliamentary scheme works, and it's fairly clear from, for example, Chilcot, is that the end user has to pay the tax and he has a right of restitution against the contractor. And what's happening here is that we're going around that system by saying, well, actually, that's all very nice, but rather than making the end user comply with his statutory obligations, we're just going to go straight to the contractor.
What's wrong with that?
Well, and
That's the whole point of 7A or 7B is to enable the statutory scheme to be departed from in certain circumstances. And that's in primary legislation. It's not a parliamentary oversight.
well, what I come back to the same point. We say, well, actually, you've got a fairly clear statutory scheme. And what that does is it makes the whole operation of PAYE entirely at HMRC's discretion. And what I would say, and I think a point which the court ought to be wary of, is that we're focusing on this discretion in these particular facts. And I fully take on board the point that the court is concerned that tax isn't being paid and that contractors seem to be benefiting from that. But as much as that might in these circumstances justify a wider discretion, there are many, many other circumstances where that wider discretion could then apply. And effectively, what you're doing is you're moving from a system where the PAYE system is clear, it's understandable, its limits are understood. So the Chilcot case being a very clear example, its limits are understood, and it's sort of you don't pay within 30 days, that's what the outcome is. To one where actually HMRC have this very wide discretion, which means that in any case where PAYE is engaged, you can go along to HMRC and go, well, actually, I don't think you should engage PAYE in this particular circumstance. So you're going to have employers coming along going, well, actually, it's a bit tough on us. We don't want to apply it this time. Employees, for example, anytime you have a Section 222 charge coming along going, well, could you exercise your discretion so we don't have this problem anymore? What happens in the case of insolvency? An amount of PAYE is owed, hasn't been paid. Can HMRC then exercise the discretion and fix the liability on the employee? Now, there are probably hundreds and hundreds of different scenarios there, but what I would urge on the court is to be cautious not to read an overwide discretion on the part of the revenue to deal with this particular situation without being alive to the wider
So
consequences.
at the moment we're addressing the question, this is being addressed on the assumption that there is a discretion.
Yes.
Yes. So then all we can consider, isn't it, is whether or, and all you're addressing is whether or not it was properly exercised in this case.
Yes, yes, absolutely, my lord.
So I'm not sure sort of interorum arguments really work here, because this is on the assumption that there is a wide discretion to start with.
Right, so on the assumption there is a wide discretion, we know what the policy is. The policy is we won't apply it if the end user knows. Now, in terms of what the end user knows or what the end user should know, we say it's perfectly reasonable for the end user to know who the people who are working in its business are employed by. But more than that, HMRC ought at the very least to be asking the end user, what is it that you actually did know? And if the end user didn't know anything, and it didn't ask anything for whatever reason, then in terms of the policy, that would be fine. But the problem is, you set a limit on the policy and then you do nothing to find out.
And I know you're addressing now the question of what did the revenue do in relation to the knowledge of the end users, but I think we have to note here, this is a different situation to a case like Chilcot, where the employer provided was the payer,
Yes.
paid the employees or provided the benefits to the employees. Here we have another employer who is paying PAYE. So the question here that the end user would have to know isn't that PAYE isn't being paid here. They'd have to investigate and find out that there was a scheme which meant that not enough PAYE was being paid. And it seems to me that's a whole different order of background difficulty, and it justifies the revenue in taking the view that in these circumstances, where there is an employer who is registered for PAYE, to say that the end user should also have to operate a second PAYE system, and of course presumably entitled to credit for the PAYE which was actually paid, would be, I have to say, seems to me bizarre.
My lord, there's a few points in there. First,
Well, usually are.
First, the fact that an end user is made liable for PAYE in respect of someone who it doesn't employ, I can see that does seem quite harsh, because they don't know what the person's been paid, and they don't necessarily have the information. And so I can certainly see why one might be sympathetic with their position, but the difficulty is that that's what Section 689 does. And so once you are an end user and you're employing someone who is employed by an overseas company, let's just say that's
We're now looking at the question of in what circumstances would the revenue say, well, notwithstanding that, we don't think that you should have to comply with the PAYE regulations.
Yes, well, I think that's clear from the policy. The revenue say that, notwithstanding that, if you knew about the arrangements, you don't have to comply.
I'm putting to you quite a simple point at the moment, which is that there seems to be a very specific position where there is somebody else who is accounting for PAYE to the revenue. And if the end user inquired, they would find that out. And the employer and the contractor would say to them, "Well, yes, I'm employed, and my employer and PAYE is being deducted from my salary."
My lord,
And they'd be under absolutely no obligation to go on and tell the contractor, the end user, that they were also receiving loans. And why would they tell them that?
well, my lord, I think the first point is that would have been an approach which might have been open to the revenue to say, well, actually, should the end user have known that they had to operate PAYE? But that's not what the policy is. That's not what the guidance says. Now, Mr. McFarlane, in his evidence, does quite often go off and go, well, I don't think that they would have known that they had to operate PAYE. But when you go back and look at the guidance, and we can go back and look at it, what that's very explicitly saying is, did the end user know about the arrangements? Now, that is a different test from knowing if you have to operate PAYE. Because, and this is a point Mr. McFarlane makes in his witness statement, he says, well, the end user would have known, even if they'd known about the loans, they would have known that these schemes are all backed up by QC opinions and the like. And so it would have been very reasonable for them to think that, well, it all works, so therefore we don't need to operate PAYE. Now, if that was the test, then it would mean that you would never, ever disapply the discretion on the basis of what the end user knows or should have known, because that would apply in every case. But that's not the policy which HMRC adopted. The policy which they adopted was, does the end user know about the arrangements? Now, in terms of what is reasonable for the end user to know, once they know that they are contracting with a worker, or contracting for the services of a worker of an offshore employee, they now know that they are at risk of PAYE, because you're not at risk of PAYE if your contractor is employed by a UK entity, but you are at risk of PAYE if they're employed by a non-UK entity. Being aware of that, one would think it would be reasonable to make some basic inquiries as to the nature of the payments made to the employee.
But as my lord put to you, if the answer comes back, my employer has registered for PAYE and is making PAYE deductions, why should the end user go any further?
Well, if the answer did come back on that, that would be sort of an interesting question. But the question hasn't been asked in the first place.
But that would be the perfectly truthful and correct answer.
Yes, it would be. What I'd submit is that an end user and end user, companies like AXA and Aviva ought to be sort of reasonably sophisticated, ought to be in a position to go, well, why are you being employed by somebody who's not UK based? And ask a few more questions. And one of those questions is, well, how are you getting paid?
But why would they even need to know that they're not UK based? The fact that they're UK based or not is relevant to whether they are registered for PAYE, but this employer was registered for PAYE, so they may not even know about it being offshore.
Well, the reason why you'd need to know is because as an end user, you have a potential liability to tax.
It puts you on the hook under Section 689,
Yes.
essentially. I mean, that is so. On the other hand, we're dealing with a pre-range as well. One always has to remember. And as you say, I mean, these were perfectly lawful tax avoidance schemes. We now know they don't work, but at the time there were lots of powerful arguments for saying they did work. And that the remuneration was effectively transmuted into partly what came through the minimum wage part of the package, and the rest of it was turned into loans from an EBT.
Yes, my lord, but I think the slight difficulty, which I'm sure sort of the claimants would all have, is that on the one hand, it's entirely reasonable for end users to assume that these things all work, but it was entirely objectionable that they took the same view. Where
That's not the exercise we're engaged in at all. It's not a comparative exercise.
well, I think
It's a question of was the revenue's exercise of discretion lawful in deciding that the end users, in circumstances where the contractors were employed by people registered for PAYE and were making PAYE deductions, should not be taken necessarily to have known that there was anything wrong.
well, I think in terms of that, when one looks at Mr. McFarlane's evidence, he was absolutely, well, you engaged in a tax avoidance scheme which was artificial, therefore everything which is coming to you, you deserve, and that's the basis of exercising the discretion. So I think on that basis, it is relevant, and it's a bit unbalanced on the one hand for him to be saying that, and on the other hand to be saying, well, it was entirely unreasonable for end users to think that they didn't have to operate.
But the contractor knows that they're getting the majority of their remuneration through a loan. The end user doesn't know that.
Well, but the end user can certainly ask, and sort of, if it's a different point, my lord. If the end user doesn't know that, that's one point. If the end user does know that and thinks, well, actually these schemes work, that's a different point. So, our position is that it's not correct to assume that the end user would not make any inquiries. the end user ought to know that if it is employing somebody who is, if it's using the services of somebody who's employed by a non-UK resident, it's on the hook for PAYE. And not, I might add, just on the hook for PAYE, as in you have to pay it, but they have the obligations to, the administrative obligations that go with it. And so they ought, as a minimum matter, be ascertaining, well, do we have any of these PAYE obligations by reason of having these contractors? That's a legal obligation which is fixed on them, which was fixed on them. Now,
help me with this. If they had said, given the information we've had, we actually think we do have a PAYE obligation here. How would that have worked if somebody was already paying PAYE in relation to this employee? What would they have done?
Well, I suspect that what in practice would have happened, and this is a point which is picked up in the Morse report, but what in practice would have happened is that they would have gone, we're not employing you if you're going to use these arrangements.
No, we're working on the assumption. We have to work on the assumption that they do employ. I mean, and it may well be that they don't find out until they're employed. Because the employee may not have told them until they've been employed for 2 months.
Yeah. Well, so working on the assumption that they did employ them, and we got a couple of examples.
That's got to be the assumption.
We've got a couple of examples in the evidence, two witnesses who were employed by employers who knew they were using these arrangements. In that case, the end user knows that the employer is employed by an offshore entity. The end user knows that the employer is using these arrangements. The end user has taken the view that, well, Rangers applies, there's no problem here, and carried on. But just as with any employer who's taken the view that Rangers applies, and then it turns out to be Rangers doesn't apply, that you don't have that problem, and then it turns out to be wrong, they're fixed with a liability. That's just the way the tax system works. You can approach things on the basis that there isn't a tax liability.
Answer my question. Assuming that they accepted liability, what would they do?
Well,
I'm just asking. I'm not an expert in this area. What would they do as a matter of a good taxpayer who accepts that good employer accepts now that they may have a PAYE liability? What would they do?
They'd account for the PAYE to the revenue, register
All
with
of
the
it?
revenue. Well, this brings back a question which came up, an issue which came up yesterday, as to what the consequence of somebody registering for PAYE whenever they are non-UK resident. Have they submitted to the jurisdiction such that they're on the hook for PAYE as regards any PAYE liability? Now, I think the revenue's position is that it's voluntary, and so they're only on the hook for the bit which they pay. It seems to me the logical consequence of that would be that the end user is liable in respect of any other PAYE liability, i.e. the amount on the loans.
So they'd have deducted the tax due as if the loans were emoluments from employment.
Yes. I think in practice they'd probably deduct it from the payments which are being made to the employer. Yeah. But certainly.
But they wouldn't know the amount of the loans, would they?
Well, this is slightly a problem with the end user provisions in the first place, is that you don't necessarily know what the employee is being paid. But there would be, presumably, you'd get the relevant tax table and apply that. So the way in which PAYE works is by reference to tax tables which set the amount of deduction to be made, which then might over-deduct and allow the employee to make a claim at the end for any tax which has been overpaid. So I think you do it that way. So it's possible within the system. It's not that it doesn't work. So the only other point I was going to make about Adu before I left is that Lady Justice Andrews does say that she didn't think that the knowledge of the end user was a material consideration. And we don't think that can be right in light of what we now know to be the policy, where actually HMRC very much say it's a material consideration. If I could take the court just to what the policy says again. So page 38 of the Judicial Review Bundle at tab 3.
So that's the smaller bundle.
Yes.
Page 38.
Yes.
This is the contentious issues panel guidance.
Yes. No, this is the second page of it, but this is the page which.
Yes, thank you.
And it's just the first sentence. We will consider use of the discretion where contractors have used contractor loan schemes with an offshore employer and where it is reasonable to assume the end user would not have been aware of or involved in the tax avoidance scheme.
But that's all directed at, isn't it? Whether or not the end user knows that PAYE should be operated. And one can see that if you go back a page, under the heading, why would we use 7A in contractor loan cases? And it's the second paragraph. If we do not use 7A in contractor loan cases, the end user could be liable to account for tax. This could be the case even though the end user was not aware of any need to account for PAYE. So that it may be that they've focused on tax avoidance on page 38, but it's directed at whether the end user knows that there is an obligation to operate PAYE and to account for the tax.
My lady, I hesitate to correct you, but the full sentence says, was not aware of any need to account for PAYE and didn't know that the contractor was avoiding tax.
Because that's all part and parcel of whether the end user knows that there's an obligation to account for PAYE.
Indeed, but there's two different things there. There's one, I didn't know I had to account for PAYE because I thought these arrangements worked. And I didn't, which would not meet that, because that would not be a case where they were not aware of any need to account for PAYE and didn't know the contractor was avoiding tax. That would be a case of, we didn't know we had to account for PAYE, but we did know the contractor was avoiding tax. So I think even based on this, that's not intended to be covered.
Right, okay. So there's two separate considerations.
Well, so if one's going to read it that way, I think we would certainly say that it has a narrower meaning. That ambiguity, I think, also comes out in the manual at page 95, where on the one hand, it talks about an end client exercising reasonable due diligence could not have been aware that they were required to operate PAYE. This is the last line before the heading in the middle where HMRC will not exercise the discretionary power. And certainly that's what Mr. McFarlane refers to in his second witness statement. But then when you see the actual, it boils down in the next bit, HMRC will not generally use the discretion where, one, HMRC possesses evidence that neither the end client was aware that the taxpayer was using an avoidance scheme with an offshore employer, or B, reasonable due diligence by the end client should have meant that they were aware that the taxpayer was using an avoidance scheme with an offshore employer. So
And it has to mean an ineffective avoidance scheme. There's nothing wrong with avoidance per se.
Yes, well, I think it must in context mean an ineffective avoidance scheme, because if it was an effective avoidance scheme, there'd be no point in exercising the discretion, because there's no tax to pay.
Exactly. So even knowing that even knowing there is a scheme, just isn't enough. You have to know that tax is actually payable.
Well, no, I don't think that's right, my lord. I think it's knowing that there's a scheme is enough. But if it's a scheme which works, then there's going to be no point in HMRC exercising their discretion, because no PAYE is due in the first place, whether by HMRC or the employer. This is presupposing that the scheme doesn't work.
Or at least presupposing that it's unclear, which of course is normally the position in these cases until there's been a test case to resolve the matter one way or the other.
Yes, although I think by the time this has come to be written, we're in a post-Rangers world where it's relatively clear that these arrangements don't work.
Sorry, I'm now forgetting what chronology. Rangers was 2017. Oh, sorry, it was 2017. Yes. All right. Thank you.
But you were saying before that they might think that the scheme did work, but from what you're saying now, that wouldn't matter. If they know it's an avoidance scheme, then that's enough.
Well, yes, I think in terms of the way in which the guidance is written, and I think we have to understand what exactly it is that the guidance is. And I think on a fair reading of this, and I appreciate it's not legislation, and so it has to be read fairly, what it's looking at is, did they know that there was an offshore employer? Did they know that there was an avoidance scheme? I don't think whether the avoidance scheme worked or not is intended to be relevant in terms of this guidance. But I do think that in that respect, Mr. McFarlane's interpretation is somewhat problematic, because he does focus on the question which you, my lord, have raised of, well, would they have known whether to apply PAYE or not?
Well, because that's what it's all about, isn't it? I mean, that's why those points are relevant. Because if it's an offshore employer, they're potentially on the 689 hook.
Yes.
And if it's an ineffective tax avoidance scheme, or might be, again, they might be on the hook. And that's, it's all directed at, should they have operated PAYE? Otherwise, why is it necessary to disapply PAYE regulations?
Well, if that's right, where were the revenue going after Rangers for PAYE? Because Rangers were aware of the avoidance scheme, but they reasonably didn't think that they had to operate PAYE because they thought it worked.
Well, maybe they were wrong not to, but that doesn't...
I mean, they were the employer too, weren't they? I mean, that was the difference. It wasn't a scheme which involved an offshore circuit of money.
But yes, but I think, well, my reading of the guidance is that an employer who knows of the arrangements ought to be subject to PAYE. An end user who is in a broadly similar position, i.e. they know of the arrangements, similarly ought to be subject to PAYE.
Sorry, forgive me. They are subject to PAYE. This is all predicated on the basis that the end user is subject to PAYE regulations, and the revenue is deciding whether to exercise a discretion to say, well, notwithstanding that, we're not going to require you to comply.
Yeah. Sorry, my lord, I'm being inaccurate in my language. Yes, the point being that if an employer knows of the avoidance scheme, they ought not to be forgiven their PAYE liabilities. Similarly, if an end user knows of the avoidance scheme, they're in an analogous position to an employer who knows what's going on, then they ought not to be forgiven their PAYE obligations. Now, that makes rational sense in terms of where you're drawing the line with end users.
Well, you can see it is, but there is, so come back to it, a completely different quality in the knowledge. On the one hand, an employer who is deeply involved in the scheme, and an end user who what they know is that somebody else is employing this person and is operating PAYE in relation to them. Seems to me that puts it into a rather different ballpark.
My Lord, I'm conscious that we're slightly straying into why the policy was set the way it was. And of course, I made in my submissions yesterday that we thought that was relevant, but we haven't been told why the policy was set, why it was. At the moment, I'm very much addressing what the policy says. And while one might say, well, actually, it could have been stricter or it could have been more forgiving, in terms of what it does say, and it seems to be fairly clear from page 95 of the manual, it's that the end user was aware that the taxpayer was using an avoidance scheme with an offshore employer, or with reasonable due diligence could have become aware of that. But what it doesn't say is that they knew they should have operated PAYE.
So you say that's irrelevant?
So we say that is irrelevant, and it's very much a feature of Mr. McFarlane's evidence that he's taking that into account.
You say that's irrational?
Yes.
Irrational to take into account knowledge of the obligation to operate PAYE?
Well, what it says, it's an irrelevant consideration in terms of what the end user knew, because our focus is very much on the failure to investigate what the end user knew. And to say that, well, there's no point in investigating what the end user knew because they wouldn't have known they had to operate PAYE. In the context of a policy, a guidance, which says the crucial issue is what the end user knew, that approach is irrational. I have said on several occasions about what Mr. McFarlane has been saying as evidence without actually taking the court to it. I think, in fairness, I probably ought to do that.
Speaking for myself, I have read it, but happy to be reminded of the precise paragraphs you're referring to.
Perhaps if I just give you the paragraph references then. So from the first witness statement, paragraph 46, 47, 48, and 55. 48 in particular.
Sorry, 46.
47, 48, and 55.
Thank you.
And from the second witness statement, paragraphs 24, 25, and 27.
I'm sorry, I missed that.
Sorry, I'm going too fast. Paragraphs 24, 25, and 27. And 48 in particular is the one where he says, well, actually, you might have thought these arrangements worked.
And all of that in 48, you say is irrelevant?
Yes.
Yeah.
In terms of the way the policy has been framed,
And we are here looking at a pre-Rangers time frame, aren't we? I mean, the dates of the assessments were, I forget when they were, it was well before 2017.
13, 14, and 15.
13,
Yes.
14, 15, thank you, yeah.
yes, my lord, I think it seems likely that part of the reason why the issue arises is because you have a potentially different analysis which applies before Rangers than you do afterwards. And you have sort of different people who are on the hook to pay the tax.
Yes, it's just, I mean, it's an obvious point, but one has to always be careful about the use of hindsight in a situation when Rangers was a momentous case, because it did deal with an awful lot of points in a way which by no means everybody expected, probably.
Yes, indeed, my lord. The point which I'd urge on the court is to do remember that it wasn't just the end users who were sort of taken by that, it was also the claimants who were sort of adopting something which they thought wasn't going to cause an issue and then obviously has. And just to remind the court of a point which I didn't make at the very start, all of this would be rendered redundant by the loan charge, but the decision was taken to sort of scale that back. So in terms of if the idea is that you entered into these, you ought to be fixed with liability, there's very clear parliamentary indication that no, that's not right. There has to be the right assessing procedures as well. And obviously, the question we're faced with is whether there are.
I think you've just been passed a note.
Yes, I've just been reminded that in terms of Rangers and the policy, HMRC were out of time to assess the PAYE income when the policy was made.
They, out of time to assess? Do you mean to make a direction?
To make a determination, sorry, yes.
Right. Yes. They had made assessments.
They'd made assessments on the
Discovery
individuals, but,
and closure
sorry, yeah, they hadn't made assessments on the end users, so they hadn't assessed, as it were, the right people.
Right, okay. So assessments on the individuals, but not on the end users.
Yes. And to go back on a point which I made before, if they'd assessed the end users, there would have been a clear route to addressing all these issues. My lady, the next point, which I think it can probably deal with quite briefly, is it aligns with our construction points that sort of broadly, even if there is technically the power, it hasn't been used for a proper purpose, or it's been used in a way which has frustrated the clear statutory scheme.
So just to be absolutely clear, because I think yesterday you said you weren't relying on improper purposes, you were relying on irrelevant considerations. But are you relying on an improper purpose?
Well, what we're saying, perhaps if I just put it in terms of we're not frustration of the statutory scheme, what we're saying is the way in which the power has been operated frustrates a very clear statutory scheme. We have clear rules on PAYE. I took you to 684 subsection 1 yesterday, which set out the obligation to create a regime for the collection and assessment of all PAYE income. And this power has been exercised so that PAYE income won't be dealt with in that way.
But it is part of the scheme. That's the problem, isn't it? I mean, the question is how it fits in and how broad its scope is supposed to be within the scheme.
No, my lord. If you go back to 684 briefly, what 6841 says is that the revenue required to create regulations for the assessment. Subsection 7A isn't part of those regulations.
Well, that's in the same section as the power to make regulations.
Yes, but it's in the same section as a power which says you'll deal with everything in terms of assessment and collection by way of PAYE regulations. And then you've got one which says, well, you can not apply the PAYE regulations in certain cases. But if you're not applying the PAYE regulations in order to assess outside the PAYE regulations, then it seems to me that that's fundamentally inconsistent with what the commissioners are required to do by subsection 1, which is assess under the PAYE regulations.
But okay.
The next point, which again I hope to deal with briefly, is the procedural legitimate expectation point based on what's in the manuals. Now, I think before I go to the manual, it'd be helpful to look at, in the additional authorities bundle, there's a House of Lords case called IRC and Heard at tab 5. Sorry, at tab 6.
Thanks, me back. Or it's not a 5 or 6.
In the additional.
Oh, it's different.
Additional. Page 65 it should be. Right?
Very distinguished junior.
And this was a PAYE credit case where the argument was effectively whether one could obtain the benefit of a PAYE credit or not. And just the short bit which I'd like to take the court to is on page 71 of the bundle. And it's Lord Mackay saying, sort of on the first full paragraph after the quotation, it follows from the provision I've just quoted that unless the commissioners or the collector have exercised powers which would enable a charge to be made against the employee in respect of sums which the employer should have deducted, the employee cannot be held liable for amounts which the employer ought to have deducted, whether or not he's actually done so. In other words, apart from the powers to which I've referred, the Inland Revenue Commissioners do not have power to claim from the employee tax which the employer was liable to deduct and pay to the commissioners, whether or not he has done so.
So that's before the Finance Act.
Yes, look, yeah. I'm not saying that this is a statement of the law because obviously we have the provisions in the Finance Act. The reason why I'm taking the court to this is because this appears to have influenced, it seems to me, what's in the revenue manuals, which I am now going to take you to.
Oh, I see.
I should say this obviously being a House of Lords case involving PAYE credits, it's relevant to a degree in relation to the jurisdiction point in that the House of Lords seem to have no problem deciding that sort of issue on an appeal from the Special Commissioners, but I will deal with that when I get to the next section.
So this is just to give us background.
Yes. So there is a statement as to sort of certainly what the law was understood to be at that time, that you could only transfer liability but through directions. We'd of course say it still represents the law, but that's very much the question before the court. So one then gets to the Compliance Operation Manual, which is at tab 75 of the Authorities Bundle, on page 2214. And we can see there the Special Commissioner's decision in the case of Demiborn highlighted a number of tax issues for employers and employees which can arise as a consequence of an employer's failure to operate PAYE. These issues relate to a situation where income tax has been paid to HMRC on PAYE income, but by the wrong legal person, such as the employee rather than the employer. The Demi-Byrne case confirmed that where an employment relationship exists, the employer is responsible for deducting tax from payments made to the employee in accordance with the PAYE regulations. Prior to the amendment to the PAYE regulations, HMRC did not have the discretion to choose whether to collect tax from the employer on the employee unless there had been a direction to transfer PAYE to the employee under either Regulation 72 or Regulation 81 of the PAYE regulations. And then there's a reference to Regulation 185. And then the final bullet point, unless there has been a direction to remove the PAYE obligation from the employer under either Regulation 72 or 81 of the PAYE regulations, the employee was entitled to recover tax paid through self-assessment subject to time limits, and HMRC could not refuse to repay on the grounds that they'd not recovered the tax from the employer. And then it says Regulation 72E to G were introduced following Demi-Byrne. And the reason for taking you to heard is that this statement is in very similar terms and would appear to be influenced by it.
Sorry, what's the relationship of this manual to the ones we were looking at yesterday in the JR bundle?
This manual is public. The ones we were looking at yesterday are not public.
I thought all manuals were publicly available.
I thought so too, my lord, but I've learned that that's not the case.
I mean, I know, of course, they used to all be private, and that gave rise to very understandable concerns about lack of equality of arms, etc. I thought the policy was then taken to make all manuals publicly available. I mean, of course, they're intended for internal use. That's a different point. But at least people were able to look at them if they wanted to.
No, I think it's addressed by Mr. Farland in his evidence that no, the manual we were taken to yesterday was not made public. And of course, you've heard our complaints that we didn't know what the guidance was, we didn't know what we were addressing, and that's very much in line with that. And what we say of that is that that's a clear statement from HMRC made to the world that in terms of transferring liability, they will only do it through the express powers. And we say that that creates an expectation as to the procedure which will be used. Doesn't create an expectation that liability won't be transferred, but that they will use the correct procedures. And that at least until HMRC had announced a change in policy going forward, we were entitled to rely on that.
You didn't rely on it.
So my learned friends made the comment that we didn't rely on it. I mean, we're entitled to rely on it in terms of saying that HMRC ought to be held to it. In terms of the fact that we don't need to rely on it, we make reference to the Azura case. Which is at tab 42 of the legislation. And the point made there is that in a case where the representation relied on, and this is paragraph 39, is that a particular procedure will be followed when the public body is exercising one of its statutory powers, it does not make sense for the court to require reliance on the policy.
Sorry, could you give me that reference again? It's my fault, I didn't.
Sorry, it's the Azura case at...
Sorry, the what case?
Azura, A-O-O-Z-O-R-A.
Oh, sorry, I sympathise in that case.
It's tab 42, which I think should be bundle 3 of the 5.
Yes, thank you. I'm getting it slowly. Yeah, thank you. I'm sorry, the paragraph number you wanted to say.
39.
That which?
Paragraph 39.
39, thank you. Yes.
I should say that I also took the court yesterday to the clamp decision, where the point was made that HMRC don't have the power to move away from a settled view of the law. That's putting the argument in a slightly different way, but we'd say it's entirely consistent with what we say here. So that completes my submissions in relation to the judicial review point.
So you would say it was an abuse of power on the part of the revenue to exercise a power in primary legislation, which we have to assume for this part of the case.
Yes, we're assuming
because their manual says that they've introduced 72G E to G.
I think if I was to put it in those terms, my old friend would make the point that that's not the way we've pleaded it. We pleaded it very much in terms that there is a procedural legitimate expectation.
But so what unless it goes to some... Don't you have to say that there's an abuse of power for them to resolve from that?
Well,
I mean,
to that extent,
it doesn't get you anywhere.
well, in terms of the procedural legitimate expectation, we're less one's balancing the unfairness of not adopting a correct procedure as against sort of what the outcome is, and we say that.
So it's so unfair to rely on the power in primary legislation in circumstances where you had a legitimate procedural.
Yes, and it's a balancing exercise because ultimately, sort of on the one hand, you have HMRC using the clear statutory procedures, and our expectation that they would do that. It's not an expectation, and I think this is relevant when one gets to the balancing exercise. It's not an expectation that we wouldn't have to pay the tax, because if they'd used regulations 80 and 81, as I showed you, they could very easily have done so, then the tax would have been payable. It's an expectation that they will use the procedures laid down by Parliament.
The end users could say that the manuals fettered the discretion to remove their obligation.
Well, yes, but I think, and going back to the clamp case, HMRC don't have a discretion to move from a settled view of the law. They decide what the law is. And what was being said there, what was being said in the Heathrow Airport case by Lord Justice Green was that a settled view of the law, HMRC just don't have the power to move away from that. And that's just the nature of HMRC as a statutory body. So you might say that in all those cases, they're fettering the discretion, but the courts are very clear that that's just a consequence of the nature of HMRC's powers.
But the consequence of your argument must be that they should be stopped from exercising the primary legislation power?
The consequence of my argument is that until HMRC altered the manuals and announced that actually going forward we will also be looking at transferring liability using our power under subsection 7A, then they are bound to use the procedure set down in the PAYE regulations. And
therefore they can't exercise the power in primary legislation.
Yeah, therefore they can't exercise the power in primary legislation. But that's a consequence of a legitimate expectation.
Yeah, that's your argument.
Yes.
Yeah, I understand.
I don't see how that would work in answer to an end user who said, please exercise that power in my favour. To say we bound ourselves not to do so, that's just not going to work.
Well, my lord, I refer you back to the Clamp and Heathrow Airport cases, which it relies on, where you had taxpayers going, please use your power to reconsider something. And what was said was, well, actually, the revenue have reached a settled view as to what the law is. They just don't have the power to do that. So it's less a point about having fettered their discretion. They just don't have the discretion in the first place if they don't have the power to move away from a settled view of the law. Well, I entirely agree it's surprising, my lord, but that is what was decided in the case, in both cases. That completes my submissions on the judicial review point. The final point, it's one which I've made earlier this morning, is to urge upon the court to have regard to the wider potential consequences that construing the discretion in such a wide way could potentially have in terms of employers, employees coming to the revenue going, you're operating PAYE in the circumstances, you ought not to. And basically, in any case where you now have a situation where somebody is subject to PAYE and thinks it's unfair, you have a potential judicial review if the revenues case is correct. We're not just concerned with this particular set of facts in the context of the power which is being exercised.
So we're moving now to the second main issue, which is jurisdiction.
Yes, which I will hope to deal with much quicker. I don't know whether now is a good time to do
it. Probably is a good time to have a short, it's 22, a little time later, but I think 5 minutes. Thank you.
Stand, please. We'll let the judges in at 10. Ladies and gentlemen, we'll let the judges back in at 10 too. Yes.
Close the other two down as well. So.
Which other two?
You've got two. You see two of the windows. Oh, the one, yeah, that one.
I close that. I sure I want to leave.
You're just leaving.
Yeah.
Sorry, you're leaving just
gadgets everywhere.
No,
Go back in. So, this is one minute.
Oh, okay.
So, where else?
We're waiting for their counsel.
Not outside. Are they out further?
Yeah, they're ready to go.
No, but are the council at the same? I'm missing a council.
Ready?
Are we missing anyone?
No one that needs.
That's it?
Yeah.
Yeah.
So, Hassan, come in.
Yeah. All right.
Come on, please.
Thank you, my lady, my lords. Moving on then to the tax appeal and the issue of the jurisdiction of the tax tribunals, which is to an extent academic because
Well, it is academic,
Yes.
but for future cases, you invite us to decide it, is that?
yes, we do. Well, you saw in our skeleton argument that we would have abandoned it if it had got rid of all of the issues on the statutory appeal. That's a position which is disputed. And so that's one of the reasons why we maintain it, because obviously there is an interest in it, and there are other issues such as costs which may flow from it.
Sorry, I didn't hear. Your voice gets quieter and quieter at the end of a sentence.
I'm very sorry.
Or else it's me. I didn't. You would have abandoned it.
Yeah, we had taken the view at one point that the principle in lec and lec applies, so that if we had abandoned this point of appeal, there was nothing for the revenue to appeal. And therefore, both this appeal and the cross appeal would fall away. And rather than having 5 days of hearing, we would have had 2.5. Having put that to the revenue, we understood that it was going to be resisted and strongly resisted. And not being in a position to engage in what would have been satellite litigation on the issue, we took the decision to move forward with it.
I see.
But that's part of the background to why it's.
Okay.
So the issue is the ability of the tax tribunals to address a PAYE credit.
Yeah.
This does seem to be a relatively recent issue. We looked at the Heard case where it went on appeal to the House of Lords from the Special Commissioners, where the issue was addressed. The other two cases which I've referred to in the skeleton argument, which actually neatly show the importance of the tax tribunal to be able to address it, are the Demon Internet and the Clifton cases, which I believe you'd be familiar with, where you have competing arguments on behalf of employees and the employer. And actually, it's sort of a case where alternative assessments work very neatly, because you can go off to the tribunal and they can fight it out among themselves as to who has to pay the PAYE, and one person does, and the other person doesn't, and things move forward.
I mean, nobody disputes that these issues can, and indeed often are, dealt with in cases where you have an existing statutory appeal for which they're relevant. I mean, the problem here is that you've got no peg. There's no peg on which to hang it.
I'm not sure I understand.
Well, I got myself wrong. I mean, for instance, I can't remember, frankly, at the moment, what the position was in Heard. But I'm not at all clear that at the moment it was a parallel to the situation which you're talking about.
I believe it was an appeal by someone who was saying that PAYE wasn't applicable, and that therefore they didn't have to pay the tax. Certainly in Clifton, that was the issue, that you had employees saying, actually PAYE, their argument was PAYE is applicable, so you can't go after us for the tax. So the assessable amount, the chargeable amount, wasn't in dispute, but the amount payable was very much at the core of the issue. And it was something which the Special Commissioner at that time was very happy to deal with. But the reason for citing it is not so much that, but for citing the very practical issues which it raises, that if you don't have the Special Commissioners able to address the application of PAYE in an employee appeal, then you create a mismatch between employers and employees, because the employer can go along to the Special Commissioner or to the tax tribunals and say, actually, this isn't a case in which PAYE applies because the payments fall outside the scope of it. If the employee wants to take a different view, as they did in that case, on the revenues case, they can't go along to the tax tribunals to do that. They have to argue it in front of a different court, which would presumably be the county court, which creates a huge practical issue. So why are we having two different courts deciding the same issue depending on who it relates to? And that seems, with respect...
But that does happen in other areas of the tax system. I'm thinking about residence cases where there's a challenge to the lawfulness of the policy, and also an appeal against the decision on residence. Gaines Cooper, half the time was spent in the High Court dealing with the judicial review, and the other half of the time was spent in the tribunal, because they raised different issues.
Yes, but I think the point in sort of Demon and Clifton is they both raised the same issue. In terms of the particular payments, did PAYE apply? And if the employer wants to raise that issue, he goes to the tax tribunals. If the employee wants to raise the exact same issue, it's been dealt with in front of a different tribunal. And what HMRC are deprived of is the ability to go, we'll issue alternative assessments, have it heard together, and you avoid sort of conflicting decisions. Now, the Gaines Cooper litigation, that was raising two related but quite different points. One concerned the application of the guidance on residence, which was non-statutory and therefore not something which could be before the tribunal.
Yeah.
The other was the actual legal position.
But isn't that the 7A, the validity of the exercise of that power, if it doesn't give rise to an issue that is within the Section 31 jurisdiction, it's analogous, isn't it?
My lady, I think perhaps we're jumping ahead a step.
Oh, okay.
Because I think one only gets to 7A if you can say that the applicability of PAYE credits and the amount of PAYE you have to pay is within the jurisdiction. And the way in which the first tier tribunal has decided it, and the way in which the upper tribunal has decided it, isn't by reference to 7A at all. They say actually the question of how much tax you have to pay, bearing in mind PAYE credits, that's not something which we, the tribunal, can decide. So, very similar to the issues which arose in Heard and in Clifton.
Okay.
And obviously, those cases didn't expressly address the issue. But what they do show is that the tax tribunals have no difficulty in addressing these issues, which can raise potentially difficult points about construction of the PAYE regulations, which aren't on any view straightforward. And from a practical point of view, you would have thought that actually it's the tax tribunals who are the appropriate forum to be dealing with them. I should say I'm making some very general points about purpose and what the legislation should be aiming at before getting into the detail of what it actually says. And in terms of what the tax tribunals do, they are intended to have exclusive jurisdiction in tax matters.
They're creatures of statute, though.
They are absolutely creatures of statute. And
that's the issue, the real issue.
Yes, I should say we absolutely accept at that point that the jurisdiction has to be found in statute.
Yeah.
But we also say that jurisdiction being found in statute, that means it's a process of interpretation, which engages the purpose of construction, for example. And so, therefore, looking at the purposes of the tax tribunals and how they fit within the judicial system as a whole, it is relevant as part of that exercise. And so that's why I'm making sort of these general points. And, for example, in terms of sort of a general judicial review jurisdiction, it might be said that, well, the tax tribunals are very badly equipped to deal with that sort of thing. I'm not sure they are, but that argument might be made. And that might be an indication that, well, actually, that's why Parliament hasn't included that sort of thing within their jurisdiction. But here, when we're dealing with PAYE regulations and their application, and it's clear that, at least in relation to the employer, Parliament has included them within the scope of the tax tribunal's jurisdiction, then it does seem a bit anomalous that in relation to an employee and arguing whether they apply or not, it's said that, well, no, Parliament hasn't addressed that issue. So yes, so I was going to go on to deal briefly with the jurisdiction of the different courts, because I think this is relevant in the context of access to justice. The first point being that the tax tribunals have exclusive jurisdiction in tax matters generally, save, of course, where they don't have jurisdiction. But I think where the tax matters, the tax tribunals are granted jurisdiction, that's an exclusive jurisdiction, and it will generally be an abuse of power to raise the same issue in other proceedings. It's the point which I make there. I think that's fairly well established. We cite the Autologic case in support of that.
You cite what?
The Autologic case, which is at tab 17 of the authorities, paragraphs 11 to 13, just to give you that reference. And it's useful to look at how that exclusivity was dealt with in the Glencore case, when an attempt was made to raise certain tax issues, which was said not to be appealable in judicial review. And that's at tab 32. Bundle. And if we could go to page 814 of the bundle.
804.
814.
Famous loss. Sorry? Another famous loss of
Just looking at paragraph 56, treating judicial review in ordinary circumstances as a remedy of last resort fulfills a number of objectives. It ensures the courts give priority to statutory procedures as laid down by Parliament, respecting Parliament's judgment about what the procedures are appropriate for particular contexts. It avoids expensive duplication of this effort, which may be required if two sets of procedures are followed in relation to the same underlying subject matter. It minimises the potential for judicial review to be used to disrupt the smooth operation of statutory procedures, which may be adequate to meet the justice of the case. It promotes proportionate allocation of judicial resources for dispute resolution and saves the High Court from undue pressure of work, so that it remains available to provide speedy relief in other judicial review cases in fulfilment of its role as protector of the rule of law where its intervention is required. And then he goes on to say that, in his judgment, the principle is applicable in the present tax context. But the point about avoiding duplication of effort in multiple courts and proportionate allocation of judicial resources, I think, is an important one in terms of designing a statutory appeal system. One would expect those sorts of considerations to be brought into mind. And indeed, I think a lot of friends cites it. In the bundle, we have the Johnson and Gore Wood case on abuse of process. And the whole point there is that you shouldn't be litigating the same thing over and over again. If two parties are going to litigate a point, they have to bring everything before the court at once. And that's the public policy there, is to avoid duplication of litigation and a waste of judicial resources, very much in line with what Lord Justice Sales was saying. And what we say is, in a dispute like this, where we're being told that actually to resolve it, you would need to go to 3 different courts, and that's been the Revenue's position. That runs directly contrary to that public policy, that you should have cases decided proportionately and without unnecessary waste of judicial resources.
Well, I mean, in the abstract, I see the force of that as a general proposition. The trouble is, one always has to come back to look at the small print and see what the statute actually provides, because jurisdiction cannot be conferred by consent. So one has to be able to find.
Well, my lord, I appreciate that. That's why.
So I'm not quite sure how far these no doubt admirable attitudes get one, because I'm sure we'd all agree in a sensible world you might have a one-stop shop in the FTT, but we don't.
Well, my lord, I think the point, and I'm quite open that these are general points, and we need to get to what the legislation says. But the point I'd make is generally that, given these public policy requirements, one ought to be striving for a sensible interpretation.
Well, for my part, though, I think the Henderson principle, which was considered in Johnson and Gore Wood, is a million miles from the question of whether there is jurisdiction in multiple tribunals for disputes, and it's not a comparable issue at all.
My lord, perhaps if I can just take you to the passage which I was referring to, which...
This is Johnson and Gore Wood.
Yes. It's tab 13 of the bundle.
Can you give us the page reference?
Sorry, if we go to page 232 of the bundle. And it's really just the comments which Lord Bingham makes about the underlying public interest. Where he's sort of 3 lines down, the underlying principle, and the underlying public interest is the same, that there should be finality in litigation, that a party should not be twice vexed in the same matter. The public interest is reinforced by the current emphasis on efficiency and economy in the conduct of litigation in the interest of the parties and the public as a whole. And it's really only that public interest which we say sort of arises here as well.
Shall we look at the statutory scheme now?
Yes, just before getting to that, a third case in which the courts have declined to look at matters which should properly have been dealt with in the tax tribunal is in relation to enforcement proceedings, the Alawilia case. Now, I should say this is mentioned in a footnote in the upper tribunal's judgment. I think in the draft it wasn't mentioned at all. They said, well, we weren't shown any case which said there was a limit on what the county court could do. And it was pointed out that actually we had referred to this case. And I think it's quite important because both in the context of what's said and the context of the statutory scheme, that there is a limit to what can be argued in the county court. Before going to the case itself, it's perhaps useful to look at Section 70 of the Taxes Management Act, which is what the case turned on. And that should be in the Additional Authorities bundle. Now, I should say this is no longer law. It has been replaced by Section 25A of the Commissioners of Revenue and Customs Act 2005, which we also have in the bundle. I'm sorry, it's page 3 of the Additional Authorities bundle.
The whole thing's been, this says it's still in force, but sections 1 to 3 were repealed.
Yeah, so sorry, yeah, the provision which we're relying on is subsection 1.
Ah, so then we need to look at page 1, don't we?
Yes. And what it says is, where tax is in arrear, a certificate of the inspector or any other officer of the board that the tax has been charged and is due, together with a certificate of the collector that payment of the tax has not been made to him or to the best of his knowledge and belief to any other collector or to any person acting in his behalf or on behalf of another collector, shall be sufficient evidence that the sum mentioned in the certificate is unpaid and is due to the Crown. So basically,
Way to prove that
yes,
outstanding taxes.
yes. I mean, it serves an obvious practical purpose. Rather than rewriting these things, an inspector can turn up to the county court with a certificate saying that tax is due and payable. And
that doesn't prevent reliance, does it, on public law defences in the county court to collection proceedings? I mean, that's the whole point of Winder and London Borough Council.
Well, what it does do is it says that you have sufficient evidence that tax is due.
Well, that's just a way of proving it's a proof of amount, shortcut to avoid relitigating that.
Well, absolutely. But what I'd say is that what it's illustrating that is in terms of the statutory scheme, the amount of tax which is due is not something which is to be relitigated in the county court.
But that's another way of saying you can't take a public law defence to collection proceedings, and it's well established you can, surely.
Yes, but would it be a public law defence to say, actually, the reason why this tax isn't due is because applying the PAYE regulations apply in these particular circumstances?
Absolutely.
Or the provision was, or that power was exercised in a way that was ultra vires or irrational.
Yeah, that would certainly be a public law defence, but I think the defence here would be that actually the tax isn't due. And so the person in the county court is faced with a certificate which says that tax is due, and you want to refight the point. And the issue is, well, can the county court allow you to refight the point? And perhaps it's worth looking at what the Court of Appeal said in Alawalia, because they said you can't.
I mean, I know this can be a tricky area and stuff. But I thought the general thrust of the authorities, certainly, at a very high level, House of Lords, so on, is that in principle you can run a public law defence to collection proceedings.
That's exactly what Winder said.
That's exactly what Winder said, yes.
Yes, but unless excluded by clear words or necessary implication, which I think was the implication of my lady, your decision in the Beadle case. And for example, one of the public law defence cases in collection proceedings is a case called Pavlovsky and Dunnington, which was about PAYE, and the revenue had exercised their discretion under Section 72 to transfer liability. And an argument was made, well, it was unfair the way they did that. The reason why that was able to be raised in that case was because there was no right of appeal in respect of Regulation 72. There now is a right of appeal expressly brought in, which might be an indication that these things are supposed to be dealt with in the tax tribunal, but that's beside the point. That right of appeal, I'd submit, probably excludes you from running the public law defence.
Oh, that's a separate point, yes, but the problem here is there is no right of appeal in relation to exercise of the discretion per se.
Yes, but well, that would be a problem because on the one hand, you have no right of appeal, so you can't raise your issue in the tax tribunals. But if you turn up to the county court, the revenue are brandishing a certificate which is sufficient evidence that tax is due. And so on the one hand, you've got the court with a document which is required to be treated as sufficient evidence that tax is due. And then on the other hand, you've got a taxpayer who wants to argue the point. Now, that's hardly a fair hearing It's a bit of an imbalance in the way in which the issues are being addressed between the sides. The legislation requires the court to treat one as sufficient evidence that tax is due. And sort of in the Alawilia case, where they were coming after having had appealed to the General Commissioners, what the court said was, well, actually, it was absolutely right to rely on the certificate, and that they didn't have a discretion to move away from it. Although the point is made in, so it's tab 15 of the bundle. It is the authorities bundle. Not the one. He says, in the second place, I also agree with Ms. Addy.
Sorry, where are you?
Sorry, at paragraph 47 on page 295.
Shall we just read it to ourselves?
Yes, well, it's really only the first sort of half of the first quarter of the paragraph where he's saying about the Section 70 certificates.
So what was the defence that they were trying to run? It looks like it was that the officer didn't have the authority to issue the assessment. But
Yeah, essentially that the assessment was wrong. It shouldn't have been agreed, it was wrong, and shouldn't be determined in the way it was by the General Commissioners, and they wanted to re-argue the point.
Sorry, wrong in what sense? In the sense it was ultra various, made without...
in the sense that
authority,
I suspect it wasn't as legalistic as that. I suspect
well, that's the question. What kind of an issue was it?
it was an issue that too much tax was said to be payable.
But, sorry, that's just another way of saying yes. But why? Why was too much tax said to have been payable? It looks to me as though it was a dispute about the authority, as my lady has said, of an irregularity in the proceedings based upon Mr. Macpherson's alleged lack of authority. And that, on the face of it, sounds like a point you could only, in the normal way, you'd have to challenge by judicial review, but you could also rely on, in principle, as a defence to collection proceedings if you could get it off the ground on the facts. I mean, that's another matter.
Well, my lord, certainly paragraph 46, accepting the submission that the statutory machinery for the appeal against notice of assessment is exclusive machinery.
Yes.
And that effectively, hence the district judge and the judge were right to conclude that the county court had no appellate jurisdiction in respect of the determinations of the General Commissioners. So certainly there was a challenge to those determinations. So that was the first point, there's no jurisdiction. The second point was that Section 70 was binding.
What were these? And were these collection proceedings? Or...
Yes, these were collection proceedings.
And there was then a determination made by the General Commissioners at a hearing at which neither the taxpayer nor the taxpayer's accountant was present.
Yes, I think basically the accountant had agreed liability on behalf of the taxpayer with the revenue, and the revenue had said, we're still going to go to the General Commissioners to get a final determination on this. They had gone, nobody had represented the taxpayer at that hearing before the General Commissioners, but the General Commissioners had made a determination that tax is due.
Oddly surprising in those circumstances.
Yeah. Well, yes.
Section 70.
Sorry.
No, go on.
Please go ahead.
No, go on.
Any application for JR would have been long out of time, far too late to raise it at the 11th hour. And that's a separate point as to whether, in principle, that the only way in which that alleged defect could have been tested would have been in judicial review proceedings.
Well, there were 2 points. Sort of going back to 46 and 47, there were 2 points in which the revenue succeeded. Firstly, that there was exclusive jurisdiction. The general commissioners were the proper place to decide this. They had decided it, and if they wanted to challenge that, they needed to appeal. And I think that it's not difficult to see why that's right.
Yeah.
But the second point, the one which I rely on, is that in any event, the court was bound by the Section 70 certificates, which suggests that sort of.
But in a case where the taxpayer didn't challenge the assessment.
But I don't think.
It just doesn't help you, does it? It doesn't get anywhere near your case.
Well, the problem which we say arises is that if the revenue turn up with a Section 70 certificate, which says that an amount is due, you can say all you like that, well, actually, you could argue the point in the county court, but it's not going to be a fair hearing where the court is starting off with the position that actually we have evidence that this amount is due and we have sufficient evidence that this amount is due, and you've got quite a large hurdle to climb. And that's quite a different, sorry.
No, well, that's a challenge to primary legislation, isn't it? I mean, I'm
Well,
not sure where that gets.
I think what it gets us to is in terms of the statutory scheme, sort of standing back and saying, well, actually, the county court, you can sort all this out there. That's not quite accurate, and one needs to have regard to the ability of the revenue to come along with certificates which put them, as they were intended to do, sort of on a higher plane in terms of things which have to be proven as between the parties.
Though it didn't stop the appellant in Winder from challenging the validity of the assessment or the certificate.
Yes, well, I think it depends upon what the nature of the challenge is. If it's the revenue have acted unreasonably in doing something, then I think there is a challenge. If it's actually this amount of tax is due, then I think one then gets into questions of exclusive jurisdiction, which takes us back in a circle to what is the jurisdiction of the first-tier tribunal.
My understanding is your concern is that the revenue might turn up with a Section 70 certificate in the county court, and that then there would be no right to challenge the certificate.
Well, it says sufficient evidence. It doesn't say conclusive evidence.
Well, the end of it says you can disprove it. But the problem in McCulloch, I understand it, is that the issue had been determined, and that's when you get the whole can't we litigate Henderson point. And the Court of Appeal says there's no appeal from the Commissioner's decision. So the county court were not an appellate body. The issue had been determined. The issue that there was no basis to challenge the county court.
Yeah, that's the first point. And
but that's not the situation that you're now postulating. You're postulating something different.
Well, what I'm postulating is that in the second place, so there was an alternative. Paragraph 47 was in the alternative to that, which was they were entitled to rely on Section 70. And Section 70 is a certificate which says, let me put it a different way. Section 70 is a certificate which says the revenue can say the amount which is due and payable, which presupposes that the amount which is due and payable will have been determined by the time the revenue come to issuing a certificate, which, sort of going further, I'd suggest presupposes a statutory scheme where those are things which are determined in the tax tribunals. Perhaps I can put it no higher than that.
These are all arguments as to why you must be right about there being jurisdiction. It seems to me that we haven't actually looked at whether there's jurisdiction yet.
Well, one of the criticisms we make...
Myself, I'm getting a bit confused.
Yeah, one of the criticisms we make of the upper tribunal is that they took a very narrow and technical approach to the construction of the legislation, and that's inappropriate, and that actually a purposive approach ought to be taken, which brought these things within the scope of the tribunal's jurisdiction, and one ought not to be interpreting legislation so as to artificially restrict that jurisdiction, bearing in mind the wider statutory scheme, and that is what sort of these general points are aimed at. But I take the point, and rather than being tin-eared, I'll take the court to the legislation now.
Thank you.
So the statutory code, I don't think there's any dispute that a basis for the jurisdiction has to be found in the legislation. I think the authority given for that is by my learned friends or the BT Pension Trustees case, paragraph 133 of that at Authorities 27. There are two issues to be addressed, and we say that they ought to be addressed separately. Firstly, the jurisdiction to address PAYE credits under Regulation 185, so the closure notice situation. And secondly, the jurisdiction to address PAYE credits under Regulation 188. And the reason why I say they ought to be addressed separately is because if one is approaching this as a matter of statutory construction, and it's different statutory provisions, it seems to follow naturally that you need to address each separately. And what you can't do is what the upper tribunal did, was address it by reference to Regulation 185 and then go, well, you'd expect 188 to be the same.
You would expect them to be the same, you say you've got to look at them separately.
You absolutely would expect them to be the same. I'd say you'd expect there not to be an issue with jurisdiction in the first place. So,
185 is discovery assessments and 188 is closure notices.
No, sorry, the other way around. 185 is closure notices.
Sorry, yeah. Okay. So do you want us to look at those?
Well, perhaps if I just take you through how this fits into the tribunal's jurisdiction, looking at the legislation bundle.
Yeah.
So the starting point is Section 3 of the Tribunal's Courts and Enforcement Act 2007, which is tab 11. Which establishes the first tier tribunal for the purposes of exercising functions conferred upon it by any act. So that's subsection 1. So the issue is to address what function has been conferred on the first tier tribunal. We see that from section 49D of the Taxes Management Act, which is at page 80, tab 1 of the bundle. I don't think I should say that any of this is controversial, but I think it is helpful to go through the steps just to see where. We see subsection 3. If the appellant notifies the appeal to the tribunal is to decide the matter in question. That is a function being conferred on the tribunal. If we go over the page to 49I, you see that matter in question is defined as a matter to which the appeal relates. So we're then left with the question of, well, what does the appeal relate to? And that's answered in section 31 on page 57. have four subparagraphs to subsection 1. And the ones which we're concerned with are B and D. So in terms of B, conclusion stated or amendment made by a closure notice, that amendment will amend the self-assessment. So the issue is, in terms of Regulation 185, does that credit form part of the self-assessment? And in terms of D, it's an appeal against an assessment, which isn't a self-assessment, so covers a discovery assessment. So the issue is, does the credit under Regulation 188 form part of that assessment?
And when the taxpayer completes his or her self-assessment under Section 8, in a case where PAYE has been deducted, the taxpayer puts in the gross amounts,
Yes.
and where does the credit doesn't appear in the Section 8 self-assessment?
Yes, it will. I don't think that's disputed. Well,
how does it? There's a white box for
certainly, I think in the tax calculation, sort of in the self-assessment, you will have a bit for credit for tax, which is already paid, which will include.
Yes.
That's the stage at which it comes in, I think, is at the stage of the calculation at the end of the assessment, rather than the...
Yes.
Maybe wrong about that.
Yeah.
But so that the gross amount is put into the tax return, and then there's a tax calculation at the end
Yes.
that reflects the PAYE credit.
Yeah, I think practically that's how it's dealt with. In terms of...
shown on your P60, won't it?
I'm afraid I don't. It's not something I don't get a P60 myself, my lord. So it's not something which I'm intimately familiar with.
Well, it says your pay for the month is X, and it says the tax deducted is Y, basically.
Yes, yes, and I suppose the
net payment is what gets paid into your bank account.
But I suppose for most taxpayers, they don't do a Section 8 self-assessment because PAYE covers their tax. That's the whole point of it.
yes.
So it's only where there is a reason for completing a self-assessment.
Yes. For example, other sources of income, or in cases where the PAYE deductions are excessive and you want to reclaim the tax. And I think it would be through a tax return that you do that. But I don't think, so in terms of the legislation, the only question which tax actually deducted forms part of the tax return. The issue turns on tax treated as deducted. So what we're focusing on is then the requirements of a self-assessment and the requirements of an assessment. And so I suppose it's also important to bear in mind that at this stage, we're not looking at issues of jurisdiction. We're looking at what would be expected in terms of a self-assessment or an assessment. And bearing in mind that these...
Well, the question at the end of the day is going to be, am I overcharged or undercharged by the assessment?
yes, absolutely. So what we're looking at is it when an assessment says the amount of tax which is payable, is that required to include, or required to give credit for the sums which should have been deducted in terms of Regulation 188? And in terms of a self-assessment, when one is required to say the amount of tax which is payable, does that include the amount which should have been deducted? In terms of assessments and the amount of tax which has to be payable, you say there's very clear authority that an assessment must include the amount of tax actually payable. And that is in terms, a practical sense, a practical requirement. And this is the Hallamshire case.
We were trying to remember whether a self-assessment form does actually require you to identify the amount of tax payable, and couldn't remember if there was a box that asked for that, or whether that's something that comes back after you've put in your self-assessment return. Can you help us about that?
My understanding, well, my personal experience is it does, because that's the bit you want to know when your accountant gives it back to you. How much tax do I actually have to pay? And so normally that will be in there.
I'm not sure it goes in an accompanying calculation, which either you or your accountant does for you. I think.
But it's not in the return.
But it's not, and sometimes revenue will do it for you. You get your return in earlier.
Yes, certainly. I'm not sure if that's still the case, but certainly that
Well, it was. Yeah. I asked them to do these.
Yes, and certainly that's been.
Yes, but I mean the Hallamshire case, it dates back a long way, doesn't it? The old days, long before self-assessment had been dreamt of.
Yes.
And it was making the obvious point that the taxpayer wants to know is the bottom line. What is the revenue asking me to pay?
Yes.
Because I'm not quite sure how far that takes on nowadays. I know there have been more recent cases, including one I was involved in myself, I seem to remember.
There have indeed been more recent cases, my lord, which have confirmed that the principle still holds good.
It's still, on the other hand, it's not a complete statement of the position, let's put it that way, because you have all sorts of very complicated statutory codes, and you always have to construe, you have to look carefully at the particular context in which the question is being asked.
That's a point which I've been making, sort of.
Yes.
Some gusto. Yes. Well, I think what I'd say about Hallamshire is, in terms of an assessment, we know it's still
an assessment by the revenue.
Yeah, an assessment by the revenue. So here we're looking at Section 29 assessments, so which feed into Regulation 188. And this is why I say I think we need to look at once one gets to Section 31, that's where you see the divergence in the statutory construction of the jurisdiction, because under one you're looking at paragraph B, and the other you're looking at paragraph D. And so if we start with assessments, because I think it's easier.
Assessment form here for somebody, and you disclose pay from this employment, total from your P45 or P60 before tax was taken off, UK tax taken off. Do you disclose that?
Yes, you don't put in the actual amount of tax. You do, yes. That's been deducted.
Yes.
Yeah.
Yes. Which you take from your P60.
So it's going back to Hallamshire. It's at tab 5 of the authorities bundle, and we're going to start on page 52. So the context of the case was that there was an appeal to the commissioners, and it said that tax was due, but they hadn't done the calculations. And the taxpayer says that unless and until the commissioners amended the return, being the amount of tax payable, not the amount of income assessable to tax, they cannot have determined the appeal. And we see on page 52 between B and C that the revenue had two alternative arguments. First, that an assessment to tax is not an assessment of tax. The revenue says that in section 29 of the Act and all the provisions dealing with appeals against such assessment, The only statutory requirement is that there should be an assessment of the amount of income assessable to tax and a statement of all matters necessary to determine the rate of tax applicable to such income. Therefore, the Revenue argues the Special Commissioners have determined the appeal in this case, since they have determined the income assessable to tax and all the facts necessary to determine the relevant rate of tax. So, going back to the distinction we talked about yesterday, the Revenue argument was all you need to have is the liability. You don't need what the amount of the obligation to pay is. And that was the argument. A second argument was that the Special Commissioners had determined the issue, and that was ultimately successful. But on the first argument, it's dealt with starting between E and F. I will deal with the Revenue's first argument, which is nothing if not bold. As everyone knows, the form of notice of assessment served by the Revenue is in every case the same. First, a statement of taxable income, then a statement of allowances, and finally a computation of the net tax payable. Section 113(3) of the Act provides that every notice of assessment is to be in accordance with the forms prescribed by the Board of Inland Revenue. I therefore assume that the Board has prescribed this form, but the Revenue now argues that the inclusion of the amount of tax payable is not required by statute. I do not find this contention attractive. It involves the proposition that the legislature envisaged the possibility of a taxpayer being liable to pay tax in an amount of which he has never been notified prior to demand for payment under Section 60 of the Act. The majority of taxpayers on receiving an assessment look only at the amount of tax payable, having neither the time nor the ability without professional advice to discover whether that sum is correct. Yet the Crown argues that it would fully have discharged its functions of assessing and giving notice of assessment without specifying any amount of tax payable, merely by stating the facts which could enable someone skilled in tax matters to compute the tax which the Crown is going to demand under Section 60. Such demand probably not being made until after the time for appealing against the assessment has expired. In my judgment, the words of the statute would have to be very clear to force the court to this conclusion. And we therefore then see the conclusion at the bottom of page 53. I therefore reach the conclusion that there is nothing in the Act which forces me to the conclusion that the assessments referred to in sections 29 and 50 of the Taxes Management Act need not include a statement of the tax payable. I therefore decide that the assessments there referred to are assessments of the tax actually payable. A man should be told what tax he has to pay, not merely given the information from which his skilled advisor would be able to decide the tax eventually to be demanded. So
That predates self-assessment.
that absolutely predates self-assessment, but in terms of that, and in terms of being told the tax you have to pay, we would say that has to reflect the credits under Regulation 188, because the tax which you have to pay reflects those credits.
Right?
The next case I'd like to look at is the Archer case, which is at tab 35. And this is the case, as we'll see, where it was argued that, well, Hallamshire is all very nice, but we're in a self-assessment world now, and it doesn't apply. And the argument there was that there had not been a valid closure notice because it didn't state the amount of tax payable.
And a closure notice again is it's an assessment by the Revenue.
A closure notice takes effect as an amendment of the self-assessment. I think that's uncontroversial, and there's authorities which. So the argument on whether the notices were proper closure notices starts on page 866 at paragraph 17. paragraph 18, we see Mr. Goldberg QC on Mr. Archer's behalf submits that the requirement in section 28(2)(b) is not satisfied unless the closure notice itself informs the taxpayer of the amount of tax he is required to pay. And then he cites Hallamshire. And then I think paragraph 20 is quite relevant in terms of what we're saying about self-assessment. Ms. Nathan, on behalf of HMRC, does not challenge the decision in the Hallamshire case, but she says that was then and it is now. The Hallamshire case was decided at a time when all assessments were made by the Inland Revenue. A closure notice, even one that amends a return, is not an assessment, or at least for the purposes of the time limits, and citing the Morris case. Moreover, there is no express requirement in section 28(2)(b) that the amount of tax payable in consequence of the inquiry be stated in the closure notice. This contrasts with the position in earlier iterations of section 28A, which said that inquiry was completed when HMRC notified its conclusions as to the amount of tax which should be contained in the taxpayer's self-assessment. And a point made further on down the paragraph, the burden of making an accurate assessment has shifted from HMRC to the taxpayer himself. And that responsibility for making an accurate assessment applies just as much to an amended self-assessment as to the original self-assessment. It's the last part of the sentence. In paragraph 22, we see agreement with the judge that the Hallamshire principle continues to apply. And in paragraph 26, he deals with the self-assessment arguments. We see the final conclusion in paragraph 31. In my judgment, the principle in the Hallamshire case still holds good, where it is HMRC who calculate the tax due despite the change to self-assessment. So that's a principle that, in terms of an assessment, it must state the amount of tax payable. And I think the point which we lay particular stress on is what's said about you should be able to know the tax payable regardless of how sophisticated your advisors are. And when one gets to the operation of PAYE and the operation of credits and notional payments, you are getting into a situation where the issues are quite difficult and you do need quite sophisticated advisors to understand what the amount of tax payable is. And it's precisely the sort of thing which Lord Brown Wilkinson was envisaging.
Struggling to just quite understand how this fits into the jurisdiction point. What is your...
Sorry, my lord. Following through, the first tier tribunal's jurisdiction requires it to have had a function conferred on it by an act. The Taxes Management Act says that when you notify a matter to the tribunal, then the tribunal has to decide the matter in issue. So the matter in issue is then defined as the issue in the appeal. So that would then take you to section 31, which is, well, what is an appeal against? And an appeal is against an assessment, which then begs the question is, well, what is contained in an assessment? Because if you're appealing against something which isn't contained in an assessment, then it's not an appeal against an assessment as such, and it's not within the tribunal's jurisdiction. But if something is required to be in an assessment and you're appealing against that, then that is something which the tribunal has jurisdiction to deal with.
Right.
So the focus has to be on what is required to be in an assessment.
And it's common ground that an actual PAYE deduction has to be in the assessment, but not that a notional PAYE deduction has to be. So that's the point that you need to address.
Yes. Now, in terms of the actual and notional, that turns on part of the interpretation of sections 8 and 9, which deal with self-assessments. In terms of just normal assessments, there are no explicit provisions setting out what needs to be contained in the assessment, which is why we rely very much on what Hallamshire says, which says what you need to have in the assessment is the amount of tax which a person has to pay. And so there's nothing else which says that in terms of what Section 29 says, it has to set it out in a particular way. And generally, a Section 29 assessment can be in slightly different formats. So, and this is why I say it's important to realize that there are two different jurisdictional questions. The jurisdictional question in relation to the assessment, where there isn't actually much in terms of a detailed statutory code, and the jurisdictional issue in relation to a closure notice, where there is a detailed statutory code in relation to what's required in terms of self-assessment. And we say very much, if what's been said is that you have to derive the jurisdiction from a process of statutory construction, then, well, as the court's been urging on me, you need to look at the legislation, and if it's different legislation for an assessment, then you need to look at that legislation, and so you need to look at the two separately. So in terms of an assessment, all we have is a reference to an assessment, and we know what Section 29 says. It says that the revenue can assess. But there are no formal requirements as to what needs to be contained. And what we rely on is the Hallamshire decision, which says, well, actually, in terms of an assessment, it must say the amount of tax which is payable.
So, I see.
Just in terms of what an assessment requires, just like to look at one more case before then looking at Regulation 188 and closing out my position on jurisdiction in relation to assessments. And that's the recent Court of Appeal decision in MCX Dunlin, which is at tab 50 of the authorities.
I'm so sorry, I didn't hear the tab.
Sorry, 50, page 1560. Now, the issue here was that MCX Dunlin had overpaid petroleum revenue tax. There had been a repayment of that, but there was a question as to whether the repayment should have been of petroleum revenue tax or advanced petroleum revenue tax. And I think it made a difference because of the interest payable. But one of the arguments raised by the revenue was MCX Dunlin brought the claim by way of a party claim form. They said, well, that's an abusive process. This is a matter which should have been brought in the tax tribunals. And what the taxpayer said was, we can't bring this to the tax tribunals because we can only appeal against an assessment. The assessment here is agreed. Tax payable is nil. So in effect, we have got nothing to appeal, that the tax tribunal would not have any jurisdiction. And we see the arguments. It starts at paragraph 50 on page 1578. Paragraph 53 on page 1580. See, Mr. Goldberg's answer, which the judge accepted, was that the dispute could never have been the subject of an appeal to the first-tier tax tribunal. And the reason being that there was nothing to appeal. Paragraph 54, supporting the judge's conclusions, Mr. Goldberg argued that there was nothing for the recipient to appeal against in the 26 August 2015 assessment. It put both the amount chargeable to tax and the net amount payable at zero. There was no reason for the all participators or MCX to disagree, and the thinking behind that assessment does not form part of it. Amount at 55, see the Lord Justice Newey's conclusion. On balance, I agree with Mr. Hewitt that all participators could have appealed. Paragraph 14 of Schedule 2 to OTA 1975, I think that's the Oil Taxation Act, allows a participator to appeal against an assessment. An assessment will show what, if any, amount of tax is said to be due, but I cannot see why the right of appeal should be limited to that figure. In fact, the judge himself evidently accepted that it would also be possible to appeal the appropriateness of the use of allowances rather than allowable losses to set against assessable profits, and a participator could potentially have very good reason to contest such a point. To my point, it would have been equally possible to appeal the fact that the 26 August 2015 assessment gave the discharge figure as 115973, when in MCX's case, the correct figure would have been 422061, higher, to take account of the APRT, which had been previously set against the PRT. It was implicit in that part of the assessment that HMRC saw the 422061 figure of the tax that they were repaying as APRT rather than PRT. Whether they were right to do so was an issue eminently suitable for decision by the FTT, and in my view, could have been the subject of an appeal to the FTT. And so therefore, there was an abusive process. Now, obviously, this is dealing with different tax, and that was the point which the upper tribunal said. But they're construing the meaning of the word assessment, which is a word which comes throughout the Taxes Acts. And what they're saying is, well, give it a wide meaning, and it's capable of covering all of the things which go into the revenues deliberations in reaching it. And that's certainly in line with the wide purpose and approach which I've been urging on you this morning.
So our route in is 31(1) B and D, interpreted broadly in line with Hallamshire, Archer, and...
Yes, I will need to take you to the legislation on self-assessment in terms of the route in via 31(1)B. The route in via 31(1)D is a bit shorter because it's just about what an assessment requires. And there are no specific requirements as to that. I should say that the upper tribunal distinguished Hallamshire and Archer on the basis that they were about who should do the work. We'd say that that's wrong. It's very clear from Hallamshire that what it's about is what a taxpayer can expect to be contained in a tax return. The whole statement about a man should be told how much he owes is absolutely consistent with that. The final point in relation to the 31(1)D route to jurisdiction, I think it's probably worth looking at Regulation 188 to see what it has to say. Regulation 188, which is tab 4, page 325 of the legislation bundle. And we can see it's headed assessments other than self-assessments, which reflects the wording of 31(1)(d). And subparagraph 2 talks about defining the tax payable by the employee. And then it fits in, as we've seen yesterday, the credit for tax which should have been deducted unless it's direction tax. The paragraph which I'd particularly like to draw the court's attention to is paragraph 5. Now, you recall, if there's a direction, then you don't get credit for any direction tax. And this is what's happened, it's talking about what, if a direction is made after the making of an assessment, the amount of any shown in the notice of assessment as a deduction from or credit against the tax payable under the assessment is to be taken as reduced by so much of the direction tax as was included in calculating the amount of tax referred to in paragraph 3A. What that is clearly anticipating is that the direction tax will be shown in the notice of assessment. Because it's saying you have to amend that.
What about 4, subsection 4?
Yeah, so subsection 4 says no direction tax is to be included in calculating the amount of tax referred to in paragraph 3A. Mm-hmm. So you could have an assessment before a direction's made. Now, I think yesterday I was explaining that Regulation 72 expressly does allow the revenue to retrospectively shift the burden of paying from the employer to the employee. And so what 5 is addressing is, well, what happens if you have a direction made after the assessment? And what it's saying is that you amend the amount shown in the notice of assessment. And the point is a short one, that suggests, in my submission, that the drafters of Regulation 188 presupposed that the notional credit would be reflected in a notice of assessment. We don't need to rely on that as such, because I think the principle, how I'm sure, is clear. But what it does show is that our position on that is consistent with the way in which the regulation is intended to operate.
So that's the more straightforward.
Yes, that's the more straightforward one, and that's the one which the upper tribunal didn't look at. You can see why sort of we think the case there is much more clear and straightforward. And I want to start there. But as I say, rather than saying one follows the other, you deal with them separately.
So we're going to turn to 185, but we'll do that, will we, after the short adjournment?
Thank you, my lady.
Thank you very much.
All rise.
Sorry?
You've done 3:15, haven't you?
Oh, yeah, I don't think it'll be that much longer. Hopefully, I'm not going to promise, but 15, 20 minutes.